Hello everybody, welcome to Commercial Law. My name's Terry Quilty, that's me in the upper corner of your picture, and I'll be with you for this course. As a starting point, I'd like to run over an introduction to topic 1, simply as an overview, and we can cover the areas in a lot more detail in class. So if we turn to the learning outcomes, which are in your course outline, you can see the three main ones: nature and sources, legislation and courts. So we're going to run through those as an overview, and at the end of this video, you should understand what we mean by Parliament, government, constitutional legislation, delegated legislation, and the two primary roles of the courts: interpretation and common law. So a good place to start this discussion is with Parliament, which we have a picture of in front of us. Now, Parliament's made up of two parts. One is the Governor-General, and this is the Governor-General here, Patsy Reddy. The Governor-General is appointed by the Queen to represent the Queen. Why do we need this? Because New Zealand is in fact a monarchy, meaning we have a queen, but that queen doesn't have any power. That power is given over to Parliament, and that's the definition of a constitutional monarchy. So our Parliament's made up of Patsy Reddy, the Queen's representative, plus the House of Representatives. Now, these are the people we elect in Parliament in our elections each year to be our members of Parliament. Now, this is where the real power lies, and where it lies is with whoever has a majority vote within this group. So if we blow this diagram up a wee bit, on the left we have the government side. Now, they're called the government in this sense because they have more than half the votes in the House of Representatives, so they in effect control Parliament, which means they have the ability to make laws. So who sits here? Bill English as Prime Minister, Paula Bennett as Deputy Prime Minister, Joyce Brownlee, Simon Bridges, etc., who are the ministers. Ministers are members of Parliament who are responsible for government departments. And behind them, we have these people here who are backbenchers, and that's all backbenchers mean. The front benchers are the senior members with the real power, and behind them are the backbenchers who vote the way they're told to vote generally. There are exceptions to that, but that is in fact the rule for most voting. On the other side, we have the opposition, and that is primarily Andrew Little, Jacinda Ardern from Labour, and also the other minor parties down the side here. On this side, we have minor parties who are we actually have parts of National here, but we have minor parties who align themselves with this group. So as we go through this process, we've brought up a table. I've got one here where we'll look at the function, who, what they are, an example in their application. So talking about Parliament, we know the who of it is the House of Representatives and the Governor-General. What do they do? Well, they make legislation, statutes, acts of Parliament. They're all interchangeable terms. Now, if we go to our website legislation.govt.nz, we can find all New Zealand legislation. Now, for today's purposes, I'm going to use the Bill of Rights Act just to demonstrate how it works. So I put a Bill of Rights into the search engine and up comes this act. I can bring it up here. Now it's useful to analyse acts as we go through. So this one is a public act, which means it applies to everybody. It was in 1990 and it was number 109. Date of assent is when the Governor-General signs it on behalf of the Queen. This is essential. At that point, it becomes a law, which was August 1990. Commencement means when does it actually come into effect as a law. Often it's straight away, but quite often it's also deferred to a later date so we can prepare for it. In this particular case, that was under Section 1. And it was going to come into effect, or did come into effect 28 days after the date it receives a royal assent. Okay, so that means that we know that it came into effect 28 days after August 28th, so that was sometime in September 1990. Now, in terms of the Act itself, look down the left here, these are the sections and they create the various laws. And for today's purposes, I wanted to just use Section 23. Now, this is a popular section in criminal law. And what it's saying is that everyone who is arrested shall be informed of the arrest and reason for it at the time. So that's 23(1)A, and that creates a law. 23(1)B creates another law, which is you have the right to consult and instruct a lawyer without delay and be informed of that right. So two aspects to that you have the right to instruct a lawyer and you've got to be told this. Now, the activating point for that is that it happens when a person is arrested or is detained. Okay, so we'll just tidy that up. Now, if we go back to our diagram, we can then say, as an example, we've got section 23(1)(b) of the Bill of Rights Act 1990. So it's always a specific section and subsection. As to application, we don't have any application because Parliament does not apply the law. It simply makes it. Which brings in the next question, well, who applies it? And that is the executive branch of government. And who are they? They are the government departments. In this example, we use the police, but it's inland revenue, education, customs, defence, fisheries, MPI. There's many government departments. And what do they do? Their job is to carry out or execute. So it executes carry out, so therefore they're called the executive branch. Now, in our example in 23(1)(b), it says you must give a person a lawyer on arrest and inform them of the reason for the arrest. Now, how do they actually do that? Well, in an application sense, practical sense, the police will give a person a phone and a list of lawyers so they can instruct and consult a lawyer on arrest. Now, if we take a scenario here, what would happen if the police saw a person they thought had committed a crime, such as an armed robbery, because they were wearing similar clothes? So they stop. Several cars stop. A number of police officers get out. They stop the person on the street and say, will you come with us to the police station? Is that person arrested and therefore needs a lawyer? Or the police take the person to the station, they interrogate them for a number of hours, after which the person admits that they were in the shop and they were carrying a gun, but it was a toy gun, and they were just pretending and playing with their friend. So the police then arrest them and charge them with presenting a firearm and attempting to rob the store with a toy gun. Now, the question for this is, when should that person have a lawyer? Should they have it at the time the police ask them to come with them, or have it at the time the police say you're under arrest? Now, making that decision is the job of our judiciary. So let's put the judiciary in down there as the third branch of government, as we call them. Now, who are the judiciaries? Well, their courts, tribunals are the judicial bodies who make decisions under statutes made by Parliament. What's their job? Well, the courts interpret the law and make sure the executive, this branch, have carried it out the way Parliament intended. So in our example, we have a law that requires a person to be given a lawyer on arrest and informed of the reason. So what's going to happen here is when a person's arrested, the court has to decide, is it when the police say you're under arrest or when the facts make it clear the person is not free to leave? Now, we know the answer to this because it's been through court several times, and the answer is that it's when the facts make it clear that person did not believe they were free to leave on reasonable grounds. Now, what is the court going to do in these circumstances? The police, on that interpretation, should have given the person a lawyer at the police station after they took them there in their car, but they didn't, which means the police failed to give the person a lawyer after being arrested, and the court's going to declare the evidence they received to be illegal and therefore cannot be admitted into court. Now, this brings in some very important aspects of our legal system, and that is that we have three branches of government: Parliament, Executive, and Judiciary, and they operate independently, and we call this separation of powers, and that's very important. The other thing is, if we group this together, just put a box around all of those, then the combined group together is called government. So that's what we mean by government or the state. Now, I know I use the term government to refer to those in the House of Representatives with the majority, and that's how it's used in the media frequently. But also, when we talk about government in a general sense, we mean all three branches together forming government. The next topic is the idea of a constitution, which runs alongside the three elements we've just been talking about. So what is a constitution? Well, we can talk about it in its two parts. One is it's the laws that create the government, the state, and it's the laws that provide citizens' rights against the state, such as the Bill of Rights Act, which we just looked at. Now, we find all these in statutes, we find them in how the courts interpret those statutes, the words of the statute, and we find it in constitutional conventions, which we'll talk about. Now, one thing we don't have is, as in America, a Constitution of New Zealand with all of the various aspects set out as they do here with their articles. What we do have is a bunch of different statutes. So, for example, we have the Constitution Act, talks about the sovereign, which means the Queen, the executive branch of government, the legislature, meaning the House of Representatives, Parliament, what it is, and the court systems. But then we have specific acts for the district courts. We have the Electoral Act, which sets out the areas in which we elect people to be part of Parliament, the House of Representatives, and the MMP voting system. We have the Habeas Corpus Act, so people aren't arrested without good reason and can be released if they are. So what we can say is two parts. We do not have it in one document. So we don't talk about New Zealand having a written constitution in the sense of one document. But it's not unwritten. It is written down in a large number of different documents. However, you will hear people say we have an unwritten constitution. Okay, we're going to have a look at this topic of delegated legislation very briefly, and we'll cover this in a lot of detail in class with some examples. But just as an overview, what is delegation? When a person delegates, they give their power to somebody else. So we can define it as giving power to another. Now, anybody can delegate, but Parliament delegates. And how does it do that? Well, the way it does everything, it passes a statute. And in the statute, it has a section usually called an empowering or enabling section or enabling act. And that is where it gives the power over to somebody else to make law. Now, what that leads us to, of course, is saying, well, who do they delegate to? So we've got three options. And we'll look first at councils, but they also give it to ministers and others. So councils make bylaws, ministers and executive council make regulations, and others, say IRD, they make all the forms which you must follow. So we can draw some lines in here that they're going to delegate their powers to any of these groups, and there can be others. Now, let's just pick on one for the moment, and we'll look at the council bylaws as an example. So if we go to our legislation and we bring up the Local Government Act. Now, through the Local Government Act, we have section 145, and you can see in here it's saying that a territorial authority, which is a council, may make bylaws for its district for the following purposes. So this is not a overall power to make any law they feel like. It has to be for their district and for these purposes. So here it's for nuisances, it's public health and safety, or offensive behaviour. So those are the three areas they can do it for. Now, there are a lot of provisions in the Local Government Act giving the power to council, so it goes well beyond just these few things. So we'll just tidy that up. Now, if we go back to our diagram, we've also got the ability of these ministers and the Executive Council and others to make rules. Now, some of the more interesting or advanced areas you might look at will be things like the Building Acts. We have a Building Act 2004, and in it, it has the ability to make a building code. Now, that's under section 16, and it allows for a building code to be put together, which has a lot of specifics in it. Now, in very much the same way that government gives laws to councils to make specific laws for the areas, it gives powers to people like the Department of Building and Housing to make very, very detailed rules. So we have the building regulations, and these set out things like structural stability and hazardous agents on site and such things. Now, if we were to go to our, I'll just minimize this, to our building standards, these are actually law. So this is the New Zealand Standard 3604, which tells us how to build a house. And this is very, very detailed. These are things like foundations, which we've got here, and what size pieces of timber, and exactly what detail has to be brought into play. And you can understand that Parliament won't sit there and debate how big this piece of concrete should be. So instead of that, they simply use their power to delegate to the Department of Building and Housing, in this case, to start making rules on exactly what should be put into a house. And that makes common sense. Now, for a good exercise in class, you could find the Building Act, and then you can tell me, can I actually go and design my house from start to finish? Now, for a little bit of extra, if you start looking through the electrical regulations and statutes, you might find out if you can actually wire your own house. And for a real challenge, tell us how big the wires have to be. So we'll discuss that in class. Okay, so let's just put this into a little bit of context. Having done all this, where do we find these things? Now, going back to our first diagram, where does delegated legislation fit into this situation? Now, I've put it in here, as you'll see, under Parliament. And Parliament's giving the power to somebody else, but it's considered to be the same as though Parliament made it itself. So it fits in there. Which executive branch enforces it? Councils. They're the ones that issue building permits. Even though a different government department makes up the rules, the councils actually execute that part of it. And we've got the judiciary sitting down here, so if a building inspector won't pass my house because he says it needs a bigger block of concrete, but the rules say I've got the right size concrete, I go to court, and the courts will interpret the law and decide if I'm right or the building inspector's right. And I'll either get my consent passed or not. If we go back to our legislation site, you'll notice up here we could do a search, and it includes legislative instruments, and that's things like regulations, but it doesn't include bylaws or rules. So we can find regulations made by Order in Council, and we will cover that in class, but we can't find the council bylaws this way. We have to search the council records for those. So now we'll just finish with our last point, and this is very much a summary. So what is the role of the courts? So we've decided number one is they interpret and apply legislation. Now, the second thing they do is, what if there's no legislation available? So if no legislation, they make and apply law. And that is called the common law or the law of precedent. And so that's common law, and it's also precedent. A precedent is an example which can be reapplied. And again, we'll go into this in detail, so we'll make that spelling a bit better. Okay, so two roles of the courts: interpret and apply legislation, as we've talked about, and if no legislation, they actually make up their own laws. But you've got to be very clear, this is number one. So we always first look for the law made by Parliament, including delegated legislation. If there is none, then secondly, we go looking for the common law, which are found in the cases. And there are databases online we can look at for that, but it's much more difficult to find the law. How important are they? Well, legislation is very important, but a large part of our commercial law we'll look at, such as contract and negligence, is common law. Okay, so we'll leave the introductory overview there, and I'll see you in class. And we'll just finish off with a picture of a pigeon. He flew past my deck, so I shot him with my camera.